Hi, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2021 Virtual Supreme Court competition. We're arguing today the case of New York State Rifle and Pistol versus Bruin. This is the semifinal round with match number 6. And today we have two teams from Paradise Honors High School in Arizona. We have Cameron Rose and Riley Grant. And from the Baldwin School in Pennsylvania, we have Grace Halak and Annie Raffaelli. Thank you so much. Petitioners, you can begin whenever you're ready.
Thank you. Mr. Chief Justice, and may it please the court, would you like a brief reading of the facts of the case?
Yes, please.
In New York, a person seeking to conceal carry a firearm must acquire a license from the state. In order to get the license, one must show a special need for self-protection, and the state will determine whether or not to grant that person the license. Robert Nash and Brandon Coach, two law-abiding citizens with no criminal records, applied for the license in the state of New York for self-defense purposes. They were denied because they did not demonstrate a special need. Nash and Coach sued Kevin P. Bruin and Justice Richard McNally with the help of the New York State Rifle and Pistol Association. New York eventually threw out their case, stating that they failed to show proper cause. Your Honor, this law violates the Second Amendment right of the people to keep and bear arms for self-defense. For this law to remain enacted is in direct opposition to the intent of the Second Amendment. The Founding Fathers drew inspiration from the 1689 English Bill of Rights for the construction of the Second Amendment. This document stated that the people of England had the freedom to bear arms for self-defense. Many other articles in this Bill of Rights are extremely similar to that of the United States, such as freedom of speech and the prohibition of cruel and unusual punishment. These values and ideas were carried on into the writing of the Constitution. Alexander Hamilton wrote in Federalist Number 29 in 1788 that the right to bear arms was the most natural defense of a free country.
So, Counselor, let me if I can interrupt you for a second. There's a lot of great history. What do you do with the Statute of Northampton? And maybe Mr. Grant can answer this question.
Are you in reference for the Statute of Northampton as to whether it should be applied in this case?
Well, I mean, how do you read the Statute of Northampton? How do you read it?
So if you look at the Statute of Northampton, it's very kind of like split even on how you can interpret it. So with the bearing of the arm, so back in like the times of what was written, so you have where kind of sort of how the weapons were back, which is like the sears, and then you have like some basic primitive firearm designs. And I believe that if we look at how the interpretation of it can go throughout time, I believe that we should be able to have like these weapons and able to keep ourselves safe over throughout the
What
time.
exactly, Mr. Grant, what exactly did the Statute of Northampton prohibit?
I believe, wasn't it to prohibit, wasn't it like certain illegally used like weapons?
Right. So how does that affect our case today?
So applying the statute of Northampton to this, so we can see that there are limitations where we can bear arms. But in this specific case, we believe that bearing handguns, which in this case is part of the case, that we feel that the Northampton ban of the firearms should be taken into account, but at the same time, there should also be a reason for it.
Okay. And unfortunately, I think your audio is breaking up just a little bit, but I think we'll have to deal with it. You may proceed with the argument.
Many of the framers believed that the right to bear arms would protect against the country needing a proper military force and would further safeguard from tyrannical government behavior, which was the reason for the founding. More recently, in 2008, the Supreme Court established in District of Columbia v. Heller that the Second Amendment must not only be applied to those in a standing military force. As stated in the majority.
So why is this history important to establish, or I guess to interpret the Second Amendment today?
This is important in determining how to establish the Second Amendment today because it shows what the founders intended with the Second Amendment and how they wished for it to be applied to the people of the United States. Although we do have to look at further developments over like the history of our country in order to determine how we should apply it now, it's important to look back at how they wanted it to be viewed because the founders were the ones that created this Constitution in order to protect us. And by looking at what they intended, it helps us to see the main points behind the amendment.
And what piece of history do you have on point that is most persuasive to leading you to the conclusion that a Second Amendment violation has occurred?
When we look at, like I was saying earlier, Federalist number 29, they were discussing the founding fathers really did not want to have a standing army in the United States. And when we look at that, the right to bear arms, as Hamilton said in Federalist number 29, was the only substitute that can derive for a standing army. We can see that they intended for the people of the United States to bear arms. And when we look back at the 1689 English Bill of Rights, it does say that it's important for the people to have weapons for their own self-defense. So if we look at those combined,
I'm going to
in order
interrupt
to
you.
have
Interrupt you, counselor. I mean, we have a 1689 Bill of Rights from another country that which we broke away from, right? That you claim supports your position, but I mean, we have a North Carolina statute which essentially implemented the Statute of Northampton, which restricted the carrying of arms in public. Furthermore, there is, to my knowledge, several statutes in the southern states post ratification of the Second Amendment, which limited the carry of firearms. Why should we look to pre-founding bills from other countries and a Federalist paper instead of looking at the tradition of several states here in the United States?
Yes, sir. So I see where you're coming from, but I feel like it's very important to get the basis from which the amendment was founded upon, because once we get that basis, we can then interpret it. While sure, we do have these statutes that are like the Northampton, as you said, in North Carolina. I feel like it's more important to rather look at where it came from and then where it has progressed forward, while then looking at it from the moment, right? It's better to get the origins rather than the middleman, if that makes sense.
And furthermore, looking at what happened in England before the founding of the United States, as my co-counselor was saying, it helps us look at the basis in which the Second Amendment was written. The founding fathers looked at what happened in England and built upon their ideas that they thought were helpful for the founding of our country. For example, they looked at an essay of crimes and punishment by Cesar Beccaria to look for things to write about in their constitutions. They did look back at documents from England in order to influence their own document writing.
So what do you think is the strongest piece of historical evidence on your side?
So, Your Honor, the strongest piece of evidence on our side would be Heller versus the of Columbia.
Historical, going back to the framing. What's the strongest piece of evidence you think is on your side?
The strongest evidence on our side would be the 1689 English Bill of Rights, because it so closely mirrors our own Constitution. Like I said earlier, they have amendments on the prohibition of unusual punishment, and it just very closely mirrors our own Constitution, and the founders did draw inspiration from it, like they did many other documents from that period of time. So it helps us look at what they intended.
So let's pivot maybe to the modern. What standard of review, what standard of scrutiny would you use to interpret the Second Amendment?
Yes, Your Honor. So the level of scrutiny which would be applied in this specific case would be strict scrutiny. This is because the law in question violates a core value of a Second Amendment, which prohibits strict scrutiny. So with this interpretation of scrutiny, we must look at the law in the most strict level, and it must restrict the least amount of people in order to ensure that the rights of the people remain the most common.
Where are you getting the proposition that when a core protection is at issue, strict scrutiny applies? Do you have a case on that?
Do you mean it's like?
So do you have
Should apply-
this court saying that when there's a core freedom at issue, we apply strict scrutiny? Do you have a case that says that from this court? Because to my knowledge, Heller merely said heightened scrutiny, correct?
I do not know the exact wording of it, but it could be heightened or strict in that case, yes.
Well, let's move on as to why it fails strict scrutiny.
Strict scrutiny. Yes, Your Honor. So strict scrutiny applies to when a core value is in fact at risk. So the core value of the Second Amendment is to keep and to bear arms. And so this New York law is prohibiting an individual such as Koch to prevent him to keep and bear arms in the state of New York.
All right, you may proceed, Counselor. About 40 seconds left.
District of Columbia v. Heller determined that the states were allowed to, the 19th century cases that interpret the Second Amendment universally support an individual right unconnected to military service. Furthermore, the Supreme Court established that the Second Amendment protects an individual right for self-defense. The New York state law prohibits citizens from concealed carrying weapons for self-defense purposes, as seen by the denial of the two's applications. As determined in Catiano versus Massachusetts, a bearable arm, as under the Second Amendment, is defined as anything a man wears.
Okay,
for
Counselor,
defense.
I think you're just out of time, but there we go. Thank you so much. All right, if the respondents can please come on camera, you will have your 15 minutes and we can begin. All right, whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Anna Raffaelli, and with my co-counsel Grace Halleck, we will be representing the respondent in this case. We contend that yes, the Second Amendment does allow the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense, and thus the New York law is constitutional and should be upheld. Petitioners argue that the New York law, which requires citizens seeking unrestricted concealed carry licenses to demonstrate proper cause, effectively bans the carrying of handguns outside of the home for self-defense. However, the New York law does not restrict concealed carry altogether, and in fact provides a multitude of avenues through which a law-abiding citizen can carry a concealed weapon for self-defense without proper cause. In fact, Petitioner Coates' license already allows him to carry a concealed handgun while traveling to and from work, while both petitioners Nash and Koch are permitted to carry handguns in less populated areas where there are subsequently less available law enforcement officers. The one situation which requires proper cause is concealed carry in public spaces outside of specific employment needs.
Yes, and such limitations on concealed carry have a deep history and tradition in America. District of Columbia versus Heller itself, which is arguably the most relevant precedent on the Second Amendment in this case, established that concealed carry bans are one of multiple longstanding constitutional restrictions on firearms in American history. Heller also established that the core of the Second Amendment was the right of law-abiding, responsible citizens to use arms in defense of hearth and home, since the need for defense of self, family, and property is the most acute.
So
Thus,
if I can interrupt you briefly, Counselor, right? I get that Heller said hearth and home. It's a lovely image, sitting in front of the fireplace, having a gun on your shoulder. But there's also some language in Heller which suggests you have the right outside the home. How do you address that language?
Yes, we don't contend that there is no right to self-defense in public. Obviously, that would be illogical, but the core of the right is of the home. And so because this doesn't substantially burden.
But so I want to make sure I get your position. Your position is that there is a right to extend outside the home?
Yes, but of course it is subject to restrictions and
Right.
regulations.
So what restrictions can that right be subject to? Because if it's a fundamental right enumerated, your friends say strict scrutiny. Why is it not strict scrutiny?
Well, we hold that this should be analyzed under intermediate scrutiny due to a lot of the language in Heller. One big part of the reasoning is that Heller lists a number of longstanding provisions that are constitutional, such as the ban on carrying of firearms by felons and the mentally ill. And all of these longstanding provisions would in fact fail strict scrutiny because they're often vague or overreaching, too broad to uphold the narrowly tailored standard of strict scrutiny. So we hold that this law should be analyzed under intermediate scrutiny.
Well, let's just assume for a minute that you're wrong and that this should be governed under strict scrutiny. Mr. Raffaelli, can this law survive strict scrutiny?
This law does not necessarily survive strict scrutiny. However, Heller did.
So you can see that if we choose strict scrutiny, you lose.
But Heller in itself kind of
There's a yes or no question. So I just want to make sure. So if we do follow strict scrutiny, you guys lose.
Yes.
Okay, well that's fair. All right, you may proceed.
For a law to pass under intermediate scrutiny, the government must be pursuing an important interest, and the means the government uses must be closely related to this interest. The governmental interest in this case is to protect public safety and prevent gun violence in public spaces. This interest is undoubtedly important, and perhaps one of the most important interests our government can have, which is protecting the health and lives of American citizens. The means the government uses, which is the proper cause requirement, are closely related to the interest of protecting public safety.
But why
It
couldn't, why couldn't they, this is Ms. Hallock, why couldn't they address public safety a different way, right? Why can the government say, we'll give you a background check, we'll make sure you can have proficiency with carrying a gun, make sure you're accurate at shooting it, we're gonna run a full background check to make sure you have nothing in your background. Why isn't that enough? Why do you have to have this good cause standard on top of everything else?
I think the good cause is especially the good cause reasoning is especially important in New York because of how highly populated it is. And so there needs to be stricter regulations in these higher population places to
So could
limit
we
the amount
have-
of firearms.
Can we have one standard, perhaps in upstate New York where it's not so populated, and a different standard in Manhattan?
I think, in fact, this law does allow petitioners to carry concealed weapons without the proper cause in less populated areas, like rural areas.
Is that right? Do they get a permit that's limited by area?
I believe they are permitted to carry concealed weapons both to and from work and
From work,
in,
but what happens if they're not in the job?
and in less populated areas, rural areas.
Not sure about that. Okay, but you can proceed.
Okay. The means the government uses are closely related to this interest of public safety. And the New York law does not restrict concealed carry altogether.
Allow me to interject, Counselor, and perhaps for Ms. Raffaelli. What is the best historical piece of evidence you have for the good cause provision, if any? Are there any historical laws that required good cause at all?
There are a couple good cause laws from the 1900s in New York. For example, the Sullivan laws, which expanded statewide licensing requirements and enhanced the penalties for possessing or carrying a concealable firearm.
Were those not discriminatory in purpose, though? Targeted specifically towards Catholics?
Well, this is solely one example of proper cause laws. There were multiple others in Massachusetts as well, in Maine, Michigan, and several Kentucky laws also incorporate.
From the 19th century.
That is correct. Yes.
Proceed with your argument.
Under the law, homeowners may keep, under the New York law, homeowners may keep and bear arms in their homes. Storekeepers may keep and bear arms in their places of business. And judges, government employees, bank employees, and people employed by state institutions may keep and bear arms during employment. And in fact, Petitioner Koch's license already allows him to carry a concealed handgun while traveling to and from work.
But if you trust them to go to and from work with a gun, why is it such an extension to let the same person carry a gun when he's going to the bank in the middle of the night to make a deposit where it might be risky, right? Why do you not trust him for that purpose?
I think it's just a public safety concern, just to limit the amount of firearms in, public and sensitive places like banks and subways and city streets. It's necessary to have stricter regulations, like the proper cause requirement.
Justice Krill, I'm sorry I cut you off. I apologize.
No, you're fine. So you're saying if a guy's traveling on a subway but to work, he can carry his firearm. Am I incorrect?
I believe that is correct.
So he's going to the work with his gun, but if he's going to the bank, going to the store with his gun, all of a sudden he shouldn't be allowed to carry it. I mean, it just, to me, it makes no sense. I'm sorry. I mean, how can you reconcile that for me?
I believe this law allows the petitioners to carry their guns to and from employment, and I believe that is specific to petitioners and their specific route to their job, and the transportation they take. So I'm actually not sure about the subway hypothetical,
Right.
if that would change arbitrarily.
Right. And the reason that they reached that decision is because, if I understand how the law works correctly, there's a magistrate who issues these permits, correct?
Correct.
Yeah. And Miss Raffaelli, if you would answer this follow up, why is it that this detached magistrate, who to my knowledge, I don't know how the magistrate is appointed, if you could speak to that, how they actually get to that position, why is it the magistrate should have control over who gets a permit based off of if they live in a rural area or what kind of job they have? Could you speak to that, please, for a bit?
Well, the purpose of having the licensing requirement being decided by a local magistrate is with the purpose of generally increasing public safety, and is a long-standing or not restriction, or a long-standing thing that is constitutionally upheld by multiple cases and many laws.
Which cases?
Or well, there are multiple laws that have been long-standing, not cases, but within the history of this country, and the country with which the Constitution was inspired by, England, which extends to this law. And to elaborate on the Second Amendment not being absolute, and there being multiple restrictions, longstanding, and having been upheld by this court. For example, in
Can I interrupt you for a minute? Let's change focus for Ms. Halak. Could you ban carrying altogether? So I know you allow it with good cause. Could the state of New York simply say no carrying at all unless you're a police officer, right? Private citizens cannot carry arms, period, end of sentence. Would that be allowed?
No, and I believe that example is quite similar to the law that was struck down in Heller, which was essentially a complete ban on carrying of handguns, and even the keeping of
Well, Heller was about keeping the house. Heller, I think we said, didn't affect what you do on the road outside the house.
Right. The main issue was that it didn't allow functional handguns inside the home.
So so again, why do you think you couldn't ban guns altogether outside the home?
Because as we've conceded, there is some right to self-defense outside of the home, because just by the nature of self-defense, there sometimes will arise a need for it outside of the home.
If you can see that,
so
why is good cause the right standard? We don't know in advance when we'll need a gun. Shouldn't it be better to simply just trust the citizenry to use discretion? They went through background checks, they have proficiency. We don't know what's going to happen. No one knows when there'll be violence, right? We don't see the future. Why can't we have a shall issue regime where you're presumptively allowed a gun unless there's a reason not to?
I think this question really gets to interest balancing and the government having to balance.
But Heller said we are not balancing interests. Heller said that, didn't say a lot, but said that we don't balance interests the way Justice Breyer would have done it in his dissent.
Right. And so we would then turn to intermediate scrutiny, which I believe this law. But in terms of interest balancing, just logically, there's and as for the reasoning behind why this proper cause restriction is necessary, just as it functions in the real world, it comes down to essentially public safety. Although the need for self-defense in public areas is unpredictable, having a large amount of guns in a public space can also lead to unpredictable and really dangerous situations. Because although
let me interrupt you there. So I know you're saying about the population and the public safety. However, the vast majority of other states, I think there's only about 7 or 8 that don't allow people to carry firearms outside their home. And I mean, they have large populations and they're dealing with the same issue. So I don't understand why New York couldn't join the vast majority of other states.
I think comparing state legislatures and regimes always gets kind of tricky because although you could argue that yes, there are states with more lax restrictions, there are also states with cities similar in population to New York that have these good cause requirements in their licensing regimes, such as California and Hawaii, Maryland, Massachusetts, and New Jersey, who all have similar regimes.
I think you named them all, but there's like 37 other states that don't have this.
I mean, that's true, but
you sure? I mean, I live in Houston, one of the fourth largest cities in the country. We have shall issue, and it's roughly the size of, it's a pretty big city.
comparing like population sizes and the numbers of states that have these regimes, I think is a flawed way to approach what is fundamentally a constitutional issue. Basing these kinds of decisions on statistics and comparisons like in the modern world is a bit flawed, I believe. And so we ask that this court look at the extensive history of concealed carry restrictions and bans to evaluate this law rather than comparing modern regimes and what we see in the world today.
Okay, and you have about 7 minutes, 7 seconds. Thank you very much, Counselor. All right, if the respondents can come back, you have your 5 minutes rebuttal time. Whenever you're ready, you can begin.
Thank you, Your Honor. Intermediate scrutiny cannot be applied to this case because a core value of the Second Amendment is being substantially burdened, which is the right to keep and bear arms. This is why strict scrutiny must be applied to this case. In District of Columbia v. Heller, the majority opinion stated that it was plainly the understanding in the post-Civil War Congress that the Second Amendment protected an individual right to use arms for self-defense. If we look at United States versus Irwin, we use strict scrutiny to criminalize the possession of firearms by individuals under domestic violence. This is because an individual's right is being limited due to previous decisions. We would use intermediate scrutiny in United States v. Blesdo, which criminalized lying about your age to obtain a firearm. This is because a normal law-abiding citizen would not lie about their age. So this is used to help with the government interest of unlawful possession. Furthermore, the incorporation doctrine of the Bill of Rights makes the Constitution applicable to the states, which includes the Second Amendment, because of the Due Process Clause of the 14th Amendment. If we go back and look at using strict scrutiny in this case, as the respondent
Counselor,
said,
if I can interrupt you, if we use strict scrutiny here, would all claims under the Second Amendment be governed by strict scrutiny?
What do you mean by all claims, Your Honor?
The right of a felon to have a gun.
Okay, Your Honor. So we believe that there should be certain limitations on the Second Amendment, such as the limitation of the right to bear arms by a felon. And also on top of that,
But so how do we know when we apply strict scrutiny? I mean, strict scrutiny is pretty strict, as the name suggests. It's very hard to prevail. Isn't it problematic?
It may seem like it is problematic, but with everything, there are always certain limitations and regulations you must ensure to create the utmost public safety. So if we apply this strict scrutiny, yes, there should be certain limitations put on it, such as no felon should be able to have the right to arms, misdemeanors, such on and so forth.
All right, you may proceed.
As the respondent said, our argument would be correct because if we apply strict scrutiny to this case, then we would have our argument.
Okay, you may proceed.
Your Honor, we yield our time.
Okay, excellent. Thank you so much. All right, so if the other team could please come back onto the camera. All right, let me congratulate both of you. What you just did was not easy. It was not easy at all. In fact, it was really hard. The sorts of questions that we're asking you are the sorts of questions you would get in a law school moot court competition. And let me tell you, all of you tomorrow could walk into a law school moot competition and compete, right? You're only, what, 15, 16, 17 years old, and you're performing at a level that you don't probably even appreciate how high of a level you're at. You're just saying you're just trying to get grilled, but you're performing at a level that is really remarkable. And I really have to commend each and every one of you for holding yourselves. You had composure, you had grace, no pun intended, right? You had, you kept your level. When you didn't know the answer, You did something you don't usually do, but you said, Your Honor, I'm not sure. And you're allowed to do that, right? You are allowed to say, I don't know. In fact, it's better to say, I don't know, than to just make something up, because that's when you get in trouble, right? So all of you had composure, your cadence, the pitch of your voice was flat. You didn't get emotional. We're talking about a very contentious topic, guns, and you didn't have any sort of invective. You responded respectfully. I know two of you are in person, two of you are on Zoom, but you handed off, I think, gently, a good transition, a very smooth transition. Think of like a relay race between one to the next. It wasn't like this sort of herky jerky. You didn't talk over each other. When the judges ask you questions, you shut up. It's so hard to do that. Oh my goodness. Because you're like in the middle of this really good answer and you think you're about to nail it. And then this idiot judge like, no, go this other way. You don't want to go. And you don't want to go the other way. You want to go where you're going. And I'm saying, no, you're going this way. It's really hard to do this. And also you brought in history. You're citing this case and going to the statue of Northampton and the 1500s. And my goodness, this is all very impressive. Every year I do this, I say it, but the field gets stronger every year. I think I recognize a couple of you from last year. It gets harder every year to compete. And you guys bring your A games consistently. So I want to say thank you so much. I mean, that's really thank you. You think you're thanking me, I'm thanking you. Ashley and Reed are my former students, and they're sort of in law school now, and hope they can maybe give you some feedback as well of things that you can take and sort of build upon for the future.
Oh yeah, it's definitely very hard questions, and it's a touchy subject, and y'all did well. I think another really important thing is that once you get a question you're not sure of, that it's okay to have like a little bit of silence and just digest the question and come up with a good answer instead of the answer that just comes to you off the bat. And another thing, I mean, that Professor Blackman touched on is when I came to law school, I didn't know that it was okay just to say, I don't know, rather than trying to make something up to seem like I did know what was going on, because I think it really just gets the opposite message across. But overall, I mean, I think y'all did really well.
Yeah, I did not let up on anybody. I asked you questions that I would ask my colleagues in moot court. I do moot court right now, and you're getting law school caliber questions when I ask you for case. I cite your stuff. Okay, which laws are you talking about? What case are you referring to? You got to have that, and you had it. So, thank you. This was awesome. I have hope for the future. So, thank you guys.
Yeah. I always like to pause and ask if the students have any questions for us. We're grilling you and making your lives miserable for an hour. What do you want to know about the law school process, about the competition, about the Supreme Court case, whatever you want to know, free open reign. Ask me anything, as they say. Go for it.
I don't have any questions. I would just like to thank you, judges, for taking the time out of you guys to stay to judge our competition. You guys had some really thought-provoking questions where we had to like sit and think like, oh man, like what does that mean?
Trust me, you're gonna go back and you're gonna watch this on YouTube. I'll put this on YouTube and you're gonna watch it over and say, oh, why should have said this? And why didn't I say that? Oh, I could have said this. Trust me, you're gonna be yourself. That's why we have rounds. So if you advance, I've been in the grading it. If you guys advance, you'll be so much stronger for the next round. You'll be like, oh, now I know what they're getting at. And that's why we have these preliminary rounds, right? The reason why we do this is to get stronger. Each round you'll get better and you'll learn from your opposing counsel, and you'll watch the video and you're going to rewatch the video and you're going to like, ugh, you hit yourself in the head with it, but you're going to learn from it. But happy to do it. And also thank Reed and Ashley. They gave up their weekend for this. So I'm grateful as well.
And I also like to thank the opposing counsel for taking that time out of their day too. You guys put up some really good arguments.
Yeah, thank you.
Thank you.
Thank you, everyone.
And any questions from Grace or Anna?
I'm curious if any of you have any thoughts or predictions on how this case will be decided, like in the real world.
Oh my goodness. Well, I hope it's not decided before this competition finishes, which does happen from time to time. I think New York is going to lose. I just don't know how. And I don't know what rule is set. The questions we're asking about, college campuses and, subways and, what are the scope of sensitive places? New York is a unique spot. It's also not the only big city. Chicago and Houston are roughly the same size, not entirely, but they're close enough. And the gun violence in Chicago is much different with much stricter gun laws as it is in Houston, where the three of us live. So I think New York loses. I don't know what the rule they establishes. I'm sure Reed asked me the same question earlier today. I told him I don't know. So I'm not giving you fluff. Same thing I told him, I'm telling you. Anything else you guys want to know? All right. Well, this was a pleasure. I hope all of you keep arguing, keep doing moot court in college, do it in mock trial in college. You all have potential for greatness. You can all be a law student one day and become an attorney, and you can do good things with your life. But thank you so much. All right, and with that,
Thank
if the
you.
student can sign off, I'll talk to the judges for a few moments, and we will move on. Thank you so much. All right, day one in the can. What do you think?
I think Riley's still here. Okay, good. It's good. It's good.
good.
It's fine.